The LDS Church and Ensign Peak Advisors settlement with the SEC. A 2018 report found the LDS Church secretly held $32.7 billion in U.S. stocks in 12 shell companies. The SEC investigated, ultimately agreeing to settle all pending charges against the church and its investment management auxiliary Ensign Peak. Ensign Peak paid a civil penalty of $4 million. The church paid a civil penalty of $1 million. 2 public documents. The SEC closed the matter by issuing 2 related documents, a press release and a cease and desist order. The 9-page order was mutually crafted and agreed upon. As such, the church cannot deny any of the facts or allegations therein. Clues reveal the extent of negotiation over language in the order, such as terminology used for the 12 limited liability companies. While the SEC's press release calls them shell companies, the order calls them clone LLCs. The relevant laws had been in place since the 1970s. Section 13F of the Securities Exchange Act of 1934 was adopted by Congress as part of a series of amendments in 1975. Section 13F requires detailed quarterly disclosure if an institution holds securities worth over $100 million and the firm has discretion, or authority, over buying and selling. The law applies to all institutional shareholders, including nonprofits or charities, such as the church. What was the point of Section 13F? Section 13F addresses several concerns regarding the impact of large institutional funds. These concerns relate to market stability, fairness to all investors, and the interests of companies who issue stocks and bonds. Without regular disclosures from large market participants, the market is less fair and less orderly. Section 13F was designed to create transparency, given the influence and impact of institutional investors. What is a Form 13F? Form 13F enables compliance with Section 13F disclosure law. It requires information about the institution, securities held, investment discretion, other firms involved with decisions, and shareholder voting authority. The SEC's sample form includes the following warning. Attention! Intentional misstatements or omissions of facts constitute federal criminal violations. Ensign Peak used a total of 13 shell companies to file Forms 13F from 2003 to 2019. Shell companies, or shell LLCs, were used to file Forms 13F, so the church could avoid disclosing its securities holdings to the public, as required by law. Ensign Peak had sole discretion, meaning it controlled every investment held in each of the LLCs. Chart graphic, timeline of total U.S. stocks held by Ensign Peak's shell companies. SEC guidance left no wiggle room. Since Ensign Peak controlled what stocks were in each LLC, investment discretion should have been reported as shared with Ensign Peak. Thus, lawful reporting would have defeated their purpose. SEC guidance on Form 13F reporting in 1978 said, if the manager makes all decisions, then of course he has sole investment discretion. If the decision-making can best be described as joint decision-making, then investment discretion should be reported as shared. The shell LLCs were located and staffed for anonymity. Hiring of so-called business managers for the LLCs prioritized secrecy over investment experience. The LLCs were given various addresses to further avoid being connected to Ensign Peak. A total of 20 managers signed Forms 13F for the LLCs, all of whom lived and worked in Utah. None exercised investment discretion. So-called investment management agreements paid lip service to the law, but did not alter Ensign Peak's reporting requirements. Each LLC had an agreement that claimed to give investment discretion to the LLC, with Ensign Peak becoming the client. But Ensign Peak leaders signed both sides of these agreements, as Ensign Peak and as the LLC. The named business managers did not make investment decisions or have shareholder voting authority. Ensign Peak was still legally required to file Forms 13F in its own name. Business managers were mere figureheads. The business managers often didn't know what stocks were in their LLCs, or even why the LLCs existed. The 13F forms were signed and filed by Ensign Peak. Signed forms attested to being signed by the business manager at the LLC's headquarters, outside Utah. But all were signed at Ensign Peak headquarters, in Utah. Business managers were to delete all voicemails, except those from regulators. Shell LLC portfolios held slices of Ensign Peak's portfolio. The Shell companies did not operate independently. Their sole purpose was to file misstated Forms 13F. Each LLC held a piece of Ensign Peak's U.S. stock market portfolio. As the portfolio grew and Ensign Peak feared discovery, new Shell LLCs were created to reduce the amount of securities held in each one. Numerous misstatements on Forms 13F. Examination of 13Fs filed by Shell LLCs found 3 misstated summary items and 5 misstatements per security. Summary section misstatements were the place of signing, the number of other managers involved, and the names of other managers involved. Per security misstatements were investment discretion, sole versus shared, other managers, and shares for which voting authority was one of 3 types, sole, shared, or none. How many misstatements were made? From 2003 to 2019, Ensign Peak's LLCs filed 268 Forms 13F containing the same misstated items. We found over 650,000 instances of untrue, incorrect or incomplete information. Every Form 13F submitted by Ensign Peak Shell companies attested that all information contained herein is true, correct and complete. Ensign Peak leadership knew the law and notified church leaders. The head of Ensign Peak from 1997 to 2020 was concurrently chairman of another large investment firm, Analytic Investors, or AIL. At AIL, all Forms 13F were filed properly, including accurate disclosure of shared discretion with other firms. Thus, Ensign Peak leadership had no confusion about the legal requirements of 13F disclosure. The first presidency was notified of these obligations in 1998. The Shell companies were discovered, but nothing changed. A 2018 report exposed the LLCs, with $32.7 billion in combined U.S. stocks. Russell M. Nelson had been church president for only a few months at the time. After the exposé, 2 LLC business managers resigned their roles, voicing concerns. Rather than fix things and comply with the law, the church found 2 new business managers. Why all the effort and legal risk? Church leaders approved these unlawful tactics, primarily due to fear that informed members might stop donating. We estimate the church received $80 to $95 billion in tithing from 1999 to 2019, the period of active violations of Section 13F disclosure law. Roger Clark, head of Ensign Peak until 2020, said the church never wanted to be in a position where people felt like, they shouldn't make a contribution. $5 million civil penalty is the largest ever for 13F violations. The church's combined civil penalty is 50 times larger than any previous fine for violations of federal securities disclosure laws. Section 13F violations are not common because the law is easy to understand and follow. We could find just 3 prior instances of civil penalties for 13F violation, settled for $12,500, $12,500, and $100,000. Timeline of key events related to the church's use of shell companies to file misstated Forms 13F in order to hide assets from members, the U.S. government, and the investing public. 3 church presidents served during this time period. During that time, the total value of all church investments, stocks, bonds, real estate and other private investments, grew by roughly 10 times, from about $15 billion to over $150 billion. The Wall Street Journal called it the best-kept secret in the investment world. Our clarifications to the church's statement, released after the SEC order was published. 4 points in the Q&A section may cause confusion. 1. What are Forms 13F? Clarification. Church answer omits 3 essential items on Forms 13F. Other managers, investment discretion and voting authority. Ensign Peak misstated those 3 essential items on every Form 13F filed by its shell LLCs. 2. Did the church know about the practices at Ensign Peak described in the SEC order? Church response. The church's senior leadership received and relied upon legal counsel. Clarification. Answer strongly implies church leaders are claiming bad legal advice. If, during the SEC investigation, the church had claimed bad legal advice, it would have been noted in the SEC order. 3. Has the reporting practice that prompted the SEC order now stopped? Church response: yes. In June 2019, the SEC first expressed concern. Ensign Peak adjusted its approach. Clarification: Ensign Peak filed improper 13Fs for 2 more quarters and remained actively in violation in December 2019 when a first presidency statement read, "The Church complies with all applicable law governing our investments." 4. Did Ensign Peak fail to comply with SEC regulations? Church response: We reached resolution with the SEC. We affirm our commitment to comply with the law, regret mistakes made, and now consider this matter closed. Clarification: Answer does not respond to the direct yes or no question. While the Church is not required to admit wrongdoing, it also cannot deny any of the serious allegations set forth in the SEC order. Sources: Please see our website for links. The Widow's Mite Report. All of the information contained in this report was obtained through analysis of publicly available sources. As new sources are found or published, our estimates may be adjusted. Please visit our webpage for all of our latest reports and estimates.